The Second Amendment isn't a suggestion. It limits government and draws a hard line between Washington and the states. In 2021, Missouri enacted the Second Amendment Preservation Act.
Lawmakers in Jeff City to give final approval to legislation that would nullify federal gun laws in Missouri.
Or SAPA for short, to keep state resources from enforcing selected federal gun rules. On February 16, 2022, the Department of Justice sued, arguing SAPA violated the Supremacy Clause. On March 7, 2023, Judge Brian C. Wimes struck the law down. On Aug. 26, 2024, the Eighth Circuit affirmed. And on October 6, 2025, the Supreme Court denied review, leaving the injunction in place. I'm right here to cut through the noise. I'll explain what SAPA actually said, why the courts ruled the way they did, and where anti-commandeering still protects state autonomy without crossing into nullification. Then I'll lay out a practical, constitutional roadmap that defends law-abiding gun owners and wins in court. Now, let's get to the facts and the path forward for Pro 2, a policy that lasts. What SAPA actually said and how it worked. Missouri's SAPA arrived as HB 85 and was codified at RSMO section 1.4, 101.485. It declared several categories of federal gun regulations invalid to this state, instructed state courts and agencies not to recognize them, and barred state or local officers from helping enforce them. SAPA also created a private cause of action. Any Missouri citizen could sue a police department or political subdivision that knowingly assisted federal enforcement, with a $50,000 civil penalty per violation plus attorney's fees. The statute listed examples: new taxes, registries, or bans affecting law-abiding owners, and it paired those declarations with a sweeping command that Missouri would not recognize such federal acts. Supporters framed this as a constitutional shield for law-abiding gun owners. Critics called it nullification. Here's the key design choice: instead of simply telling state officers, "Don't spend resources on X," SAPA said, "Those federal laws don't exist here." Then punished voluntary cooperation. That wording matters because the Supremacy Clause forbids states from declaring federal law void, even while the anti-commandeering doctrine lets states decline to help. In short, SAPA tried to combine non-cooperation with invalidation and civil penalties, an aggressive mix that would drive the later rulings. Courts noticed that conflict. How DOJ framed the challenge. The Department of Justice, or DOJ, filed suit on February 16, 2022, casting SAPA as a Supremacy Clause case. Rather than trying to commandeer Missouri officers, DOJ argued the state had purported to invalidate federal law and had penalized cooperation with federal officials. The complaint cataloged harms Missouri agencies withdrawing from ATF task forces, chilled information sharing, uncertainty inside joint operations, and state laboratories limiting assistance. By tying those facts to the statute's text and penalties, DOJ claimed concrete injury to federal operations that an injunction could redress. Strategically, that framing avoided a fight over the Second Amendment's substance and instead targeted the statute's mechanics. DOJ emphasized that anti-commandeering lets a state decline assistance, but it does not permit a state to prohibit voluntary cooperation or declare federal law invalid to this state. The requested remedy, a declaration and injunction against SAPA's enforcement, aimed to remove obstacles while leaving Missouri free to set policy priorities through lawful non-cooperation. In short, the federal government said SAPA wasn't a neutral choice to conserve resources. It was an attempt to disable federal gun laws inside Missouri by legislative fiat, with a bounty-style civil penalty to deter collaboration. The district court's ruling. On March 7, 2023, District Judge Brian C. Wimes held that SAPA is unconstitutional
Federal Judge Brian Wimes in Kansas City is ruling that Missouri's Second Amendment Preservation Act violates the Supremacy Clause
and enjoined any and all implementation and enforcement. The opinion stressed three pillars. First, the Supremacy Clause. Missouri cannot instruct its courts and officers to treat valid federal gun statutes as invalid to this state, because federal law is the supreme law of the land. Second, the statute's penalty scheme by threatening $50,000 per violation and attorney's fees. SAPA impermissibly punished voluntary cooperation with federal officials and chilled information sharing and joint operations. Third, standing and harm the record showed withdrawals from ATF task forces and disruptions inside intergovernmental work, which the court credited as real, traceable injuries. Judge Wimes was explicit that anti-commandeering still protects a state's choice not to expend resources. What crossed the line was nullification language plus bounty-style penalties. He declined to blue pencil the statute because the operative provisions were interdependent, all flowing from the state's declaration that certain federal laws were void in Missouri. The result was a permanent injunction and a clear message if a state wants non-cooperation. Draft a resource allocation rule, not a law that purports to erase federal firearms statutes. That distinction respects both structure and liberty in practice. The Eighth Circuit's holding supremacy versus invalid to this state. On August 26, 2024, a unanimous Eighth Circuit panel affirmed the district court and kept the injunction in place. Two threshold points mattered. First, standing the United States showed concrete injury because SAPA prompted withdrawals from ATF task forces, chilled information sharing, and impeded joint enforcement, harms traceable to the statute and redressable by an injunction. Second, remedies federal courts may restrain state officials to prevent interference with federal law. On the merits ratio, the panel drew a line. States may decline to assist federal enforcement under anti-commandeering, but they may not achieve that policy by declaring federal law invalid to this state. The Supremacy Clause governs ends and means. Missouri's means: non-recognition of federal statutes, commands to state courts to treat them as void, and $50,000 penalties for cooperation, crossed into nullification, not non-cooperation. The court then addressed severability. Because SAPA's penalty scheme and non-recognition language were interdependent, the panel refused to blue pencil isolated sentences, remove the invalid declaration and the penalties collapse. Remove the penalties and the invalid command still conflicts with Article 6. The act could not be salvaged piecemeal. Finally, the panel pointed to a lawful alternative if a state prefers to withhold assistance. It can adopt resource allocation rules, insist on written MOUs, and accept political accountability, all without declaring federal law void or punishing voluntary cooperation. That is the constitutional lane for pro-Second Amendment states seeking durable, court-proof reforms, the anti-commandeering doctrine, in plain English. The anti-commandeering doctrine is a structural shield for the states. In New York v. United States, 1992, the court barred Congress from commandeering state legislatures to administer federal policy. In Prince v. United States, 1997, it barred commands that local sheriffs perform Brady Act background checks. No commandeering of executive officers. In Murphy v. NCAA 2018, the court made the rule explicit. Congress cannot dictate a state's lawmaking, even by forbidding a state to repeal its own laws. Bottom line, Washington may regulate individuals, it may not run the states. Thus, lawful non-cooperation is always available. A state may decline to devote personnel, funds, or databases to federal priorities, but anti-commandeering does not authorize nullification. States cannot instruct their courts to treat federal statutes as void, cannot penalize voluntary cooperation with federal officers, and cannot rebrand valid federal law as an intruder within state borders. The Supremacy Clause makes valid federal law supreme. For pro-2A policy, this is liberating. We can pass clean non-cooperation laws that target state resource allocation, require transparent MOUs for any task force, and protect due process and local control. Pair that with targeted Bruin challenges on text, history, tradition, win by staying in the anti-commandeering lane and fighting the merits where history is strongest. That defends the Constitution and Second Amendment. On October 20th, 2023, Missouri sought emergency SCOTUS relief to reinstate SAPA pending appeal, denied, signaling no support for nullification language or bounty penalties. Fast forward to October 6, 2025. SCOTUS shut the door on Cert AC, locking in the injunction and killing SAPA for good. No merits debate, just a tombstone for nullification. What states still can do. Lawfully, here's the lawful, court-proof lane for states that want to protect law-abiding gun owners while respecting the Constitution's structure. First, write clean, non-cooperation statutes that control state resources, personnel, databases, facilities, without declaring any federal statute void. A state may decide, as a policy matter, not to assign officers to particular ATF task forces or not to process certain requests unless a written MOU sets terms, oversight, and data safeguards. That is exactly what anti-commandeering permits under New York. Prince and Murphy. Second, prohibit state-level penalties for voluntary cooperation. If a local agency chooses to partner with federal officers under an approved MOU, the remedy is political accountability, not a $50,000 civil bounty. Third, codify prioritization, devote state resources to violent felons, due process violations, and prohibited person cases, not technical paperwork traps for the compliant. Fourth, insist on transparency, publicize MOUs, audit joint operations, and require annual reports to the legislature. The Eighth Circuit practically handed this roadmap to Missouri: pursue your policy goals by lawful means or expect preemption problems. Do that, and you keep the moral high ground, defending individual rights, control, and public safety, while denying adversaries the nullification talking point. That's how truly durable pro-2A policy is built. Practical impacts for Missouri cops and gun owners. With the injunction unchanged, Missouri officers can rejoin ATF task forces, share information, and prosecute state gun crimes without fearing SAPA penalties. Federal law never required state officers to enforce it. Federal agents can enforce federal statutes themselves. What SAPA's wording did, by threatening $50,000 civil damages and labeling federal rules invalid to this state, was to create uncertainty that led some agencies to pause joint work. The record the courts relied on described withdrawals from task forces, chilled data sharing, and confusion about who could do what. The practical reset is simple: cooperation resuming where it serves local safety, and chiefs, sheriffs, and prosecutors regain clarity about their lawful options. None of this prevents the state from adopting non-cooperation rules that prioritize violent crime enforcement, require written MOUs, and guard due process. For gun owners, the immediate effect is clarity rather than new prohibitions. Your state rights and responsibilities remain defined by state law, while federal rules are enforced by federal officers or challenged in court under Bruin's text history tradition test. The bigger strategic move is to invest in state-level crime control and target federal overreach through focused litigation, not symbolic statutes. Strategic Roadmap Pro 2. A wins that survives scrutiny. My roadmap is principled and practical. First, separate the Second Amendment merits from federalism mechanics, bring targeted Bruin challenges that test federal rules against text, history, and tradition, rather than declaring them void inside a state code. Second, pass clean non-cooperation statutes that govern state resources, personnel, databases, facilities, without branding federal enactments invalid to this state. Third, require written MOUs for any joint task force, with clear scopes, due process safeguards, and annual reporting to the legislature. Fourth, prioritize prosecutions that actually reduce violence, use state power against prohibited persons, straw purchasing, and violent felons, not technical paperwork infractions for the law-abiding fifth message. Clearly, the Constitution protects both individual rights and the anti-commandeering limit on Washington's reach. When we defend both, we win in court and with the public. Finally, invest in litigation infrastructure attorneys who master historical sources, expert historians, and coordinated cases that present the strongest records. That is how we secure durable victories that protect law-abiding gun owners today and in the long run. Ground these choices in New York 1992, Prince 1997, and Murphy 2018 to demonstrate faithful adherence to binding Supreme Court precedent. Here's the bottom line. SAPA fell not because courts rejected the Second Amendment, but because its nullification-style design, declaring federal law invalid to this state and punishing cooperation, collided with the Supremacy Clause, as the Eighth Circuit affirmed, and the Supreme Court left undisturbed on October 6, 2025. The guardrails remain. States can decline to assist under anti-commandeering, and citizens can attack specific restrictions through Bruin's text history tradition test. Our job is to use the right tools for the right fight, clean resource allocation laws for federalism, focused litigation for rights. In the full video, I'll move next to concrete templates for lawful non-cooperation and a short list of winnable Bruin targets. If you value principled, effective 2A strategy, this channel is your home. Subscribe, share, and stay engaged. For reference, Prince, New York, and Murphy outline the limits on federal power and the lawful space for state policy choices with clarity.